A constitutional challenge to hanging as the sole method of execution. A ruling on whether a rejected Section 156 subsection 3 application can prevent a later FIR, and major directions to curb the influence of black money in elections. Let's take a quick look at this week's important Supreme Court updates. First, on 17th August 2026, in State of Karnataka Anr versus Prathik Parasrampuria, the Supreme Court issued important directions to curb the use of money and inducements during election. The court directed that suspected election-related cash or asset seizures must be reported within 24 hours with reasons. Election-related FIR investigations should ordinarily be completed within 1 year with quarterly status reports to the Election Commission. Cash exceeding ₹10 lakh must also be reported to income tax authorities. On 18th August 2026, in Rishi Malhotra Anr versus Union of India, the Supreme Court dismissed a challenge to hanging as the method of executing death sentences under the CrPC 1973 and BNSS 2023. Relying on earlier decisions upholding hanging, the court found no sufficient scientific or empirical evidence to reconsider the issue. However, it clarified that future reconsideration would remain possible if compelling new evidence emerges. Lastly, on 19th August 2026, in Pramod Kumar Shukla versus State of Uttar Pradesh, the Supreme Court held that rejection of an application under Section 156 subsection 3 CrPC 1973 does not prevent a subsequent FIR on the same or similar allegations. Such rejection is not a final decision on the merits and does not attract res judicata. Where an FIR discloses cognizable offences, questions regarding the evidence must be decided through investigation and trial. And that's all for this week's judicial updates. Stay tuned with Law Times for more insightful legal updates. Thank you.